Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in to the October 21 term of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On March 31st, the court decided Badgerow v. Walters, a case which concerned judicial supervision of arbitration. Joining today to discuss this decision and its implications is Jennifer Dickey, Associate Chief Counsel at the U.S. Chamber Litigation Center.
Denise Badgerow was a financial advisor working for a firm headed by three independent franchise advisors of Ameriprise. She entered into a FINRA arbitration agreement as part of that employment. That's the Financial Industry Regulatory Authority. While she was working for the firm, she made allegations of workplace harassment to Ameritrade, along with alleged violations of federal securities laws, SEC regulations, and FINRA rules. Then she was fired. She initiated a FINRA arbitration proceeding against respondents, that is, the principals of her former firm, repeating many of the same allegations of violations of federal law, along with allegations of violations of whistleblower and other Louisiana state laws. The FINRA panel issued an order dismissing Ms. Badgerow's claims with prejudice. Ms. Badgerow then sought to vacate the arbitration award in Louisiana state court, alleging that it was obtained through fraud. Respondents removed the case to federal court, citing federal question jurisdiction, and moved to confirm the award. Ms. Badgerow sought a remand, contending that there was no subject matter jurisdiction because the only issues at stake in her motion were state law issues concerning her allegation of fraud. The district court denied the motion to remand and confirmed the arbitration award. The Fifth Circuit then affirmed, applying the look-through method for assessing jurisdiction. That method involves looking through an application to compel or vacate an award to the underlying arbitration proceeding to see if that dispute between the parties arose under federal law. The Supreme Court held in a case called Vaden that the look-through method applies to petitions to compel arbitration. It did so based on particular language in FAA Section 4, which states that a party aggrieved by the alleged failure, neglect, or refusal of another to arbitrate under a written agreement for arbitration may petition any United States district court which, save for such agreement, would have jurisdiction under Title 28 in a civil action or an admiralty of the subject matter of a suit arising out of the controversy between the parties for an order directing that such arbitration proceed. Essentially, that language in the Federal Arbitration Act is directing a court to look at the underlying controversy between the parties and think about whether that controversy is one that would belong in federal court except for this arbitration agreement. But because Sections 9 and 10 of the FAA, which have to do respectively with applications to confirm and vacate arbitral awards, do not include that look-through language, a circuit split developed following Vaden over whether the rule applied to those applications. The Third and Seventh Circuits decided not to apply that rule, while the First, Second, Fourth, and eventually the Fifth decided to apply it. The Supreme Court granted certiorari to resolve the conflict. The court held that the look-through method does not govern applications to confirm or vacate arbitral awards under the FAA. The court started from the proposition in its precedents that the FAA does not itself grant federal jurisdiction. So these applications to confirm or vacate arbitral awards belong in federal court only if they satisfy other bases for federal jurisdiction. The court then noted that while Section 4 had text that basically cried out for a look-through method, Sections 9 and 10 do not. As relevant, Section 9 says merely that if the parties in their agreement have agreed that a judgment of the court shall be entered upon the award made pursuant to the arbitration, and shall specify the court, then at any time within 1 year after the award is made, any party to the arbitration may apply to the court so specified for an order confirming the award. And if no court is specified in the agreement of the parties, then such application may be made to the United States court in and for the district within which such award was made. Section 10 says that the United States court in and for the district wherein the award was made may make an order vacating the award upon the application of any party to the arbitration when certain conditions are met. For example, an award procured by fraud. The Supreme Court reasoned that Congress could have included the look-through language in sections 9 and 10, or it could have drafted a global look-through provision. Instead, because it included that language only in section 4, the court would not apply it to sections 9 and 10. Unsurprisingly, respondents did not come to the Supreme Court with no textual arguments. Instead, they argued that there in fact was a global look-through provision in section 6. Section 6 says that FAA applications, quote, shall be made and heard in the manner provided by law for the making and hearing of motions, end quote. And jurisdiction over motions comes from the underlying action. To avoid rendering Section 4 surplusage with this argument, respondents also said that Section 4 was better understood as a venue provision, allowing any federal court that would have jurisdiction over the underlying controversy to be an appropriate venue for the motion to compel. But the court rejected those arguments. Section 4 doesn't include the word venue, Vaden did not understand it as a venue provision, and the clearest statement of the look-through rule was in Section 4 rather than 6. The court recognized as thought-provoking some of respondents' arguments about a uniform jurisdictional rule that would apply across the FAA. It simply found them insufficient to deviate from its view of the text. The court viewed it as sensible to leave Section 9 and 10 applications to state courts, noting that disputes over awards typically involve issues of state law, even if the underlying dispute concerned federal law. And although the FAA was enacted in part in response to concerns that states would not enforce arbitration agreements, the Supreme Court said that it had not detected any congressional worry about judges' willingness to enforce arbitration awards already made. Justice Breyer was the lone dissent. He believed that the majority's interpretation created unnecessary complexity and confusion. He noted that the majority's reasoning would extend to Sections 5 and 7 of the FAA. Section 5 authorizes a court to appoint an arbitrator, and Section 7 allows a court to compel the attendance of persons whom the arbitrator had summoned. As a practical matter, he asked how you could even figure out the amount in controversy in an application for appointment of an arbitrator, or the summoning of a witness. How much is that witness's testimony even worth? And whether the parties, for diversity purposes of a motion relating to summoning a witness, are the parties to the arbitration or the summoning party and the witness. He also emphasized that the court did not even know for sure that state courts have the same powers under the FAA that federal courts have. At bottom, he saw no reason to slice and dice the FAA for jurisdictional purposes as the majority did. He thought the simpler approach better fit the purposes of the FAA and its legislative history. And as he often has, he called for an approach that, quote, would allow the statute and the law to work better and more simply for those whom it is meant to serve, end quote. A few takeaways from this decision. First, the decision is a good demonstration of the importance of textual arguments at the Supreme Court these days. This case was won and lost based on the court's view of the text, and in analyzing the text, it seemed very moved by the specific language in Section 4, as opposed to arguments rooted in more general text or structure. Second, it is hard to say how much the fear of federal courts being overwhelmed by arbitration applications is motivating the court, but there are some indications that this arbitration boogeyman is in the background here. For one, when the majority opinion discusses its precedent holding that the FAA does not itself confer federal jurisdiction, it expressly, maybe breathlessly, depending on how you read it, notes that, quote, were it otherwise, every arbitration in the country, however distant from federal concerns, could wind up in federal district court, end quote. And it never actually endorses its precedent on this point as the best reading of the FAA. Indeed, Justice Breyer in dissent suggests that it is not. But of course, the federal courts are quite busy. For decades, federal court officials have appeared before Congress to ask for more judges based on serious caseload difficulties. Congress has basically been unable to act because of partisan disputes about who would fill those judgeships. So it is perhaps understandable that the Supreme Court would be wary of a rule that could exacerbate the caseload of the federal courts. Now, I said above that this case was won and lost on the text, and I do believe that that's true, but it's possible that this concern may have been playing in the back of at least some of the justices' minds as they were looking at the text here. And that said, I think the third observation I would make is that this decision won't totally avoid that litigation problem for the courts. I would fully anticipate litigation over many of the questions Justice Breyer noted in his dissent regarding how the diversity rules apply to these applications. Who, in fact, are the parties? How do we determine the amount in controversy? What federal issues are present on the face of applications to confirm or vacate awards? Especially as sophisticated parties may be trying to put those issues front and center to get into federal court instead of state court. And if states fail to provide equivalent procedures to the FAA's arbitration procedures, I could even imagine litigation over that, given that the majority declined once again to weigh in on whether the FAA's procedures themselves apply in state courts, stating instead that Section 2 carries with it a duty for states to provide certain enforcement mechanisms equivalent to the FAA. Arbitration agreements, in the end, are very prevalent in America today, and despite the fact that arbitration itself is about resolving disputes outside of courts, many interesting arbitration questions are being litigated in courts every year. In fact, there's 4 other arbitration cases at the Supreme Court this very term. Badgerow may prevent some applications to confirm or vacate arbitral awards from being heard in the federal court, but I doubt it will stem the tide of this litigation.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.